Just a minute. We have to be quiet. This is case number 24-0137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so we, actually I see over here there's a red jacket. I see them. Yeah, okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't see any pretrial motions filed, or did you file any?
I did not.
All right.
I did not see the warrant for any, so I did not file any.
All right. Now, what's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, counsel?
It's protection.
I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point...
Buckle up, courtroom junkies, because today's saga has everything a delusional defendant, a fed-up judge, and the kind of legal smackdown that makes you want to frame your law degree from YouTube University. We're diving into the case of Brian Keith Taylor, a man charged with aggravated trafficking and meth possession, who believes that reading a law book once gives him the right to overrule his own court-appointed attorney. From the moment he opens his mouth, Taylor is determined to self-destruct and the judge. Oh, he's not pulling any punches. Watch as legal ignorance meets judicial fury in one of the most brutally honest pretrials we've ever seen.
Aaron, I got motions. I'd like to file.
Well, you're not representing yourself. You have an attorney. And so...
I know that.
Well, wait a minute. Just wait a minute. I'm going to address this. And under the rule, motions, if you have an attorney, only your attorney can file a motion. So if you prepare something that you want to file, I have ordered our clerk's office not to accept those. They will not accept them because you are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake, and you haven't asked for that, and there's be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient and listen, okay? One of your problems may be that you want to speak instead of listen, and that's a big mistake too. So, getting back to my point is that, there's not what's called a hybrid representation system in Ohio, and that's a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he has reviewed these with you and didn't find anything that had any legal merit, arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to file any kind of number of motions that based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap. So that's where we're at. Now, going back to my question, are you rejecting the plea offer?
Yes.
Yes? Okay, then we will have a trial on April the 7th. All right, so does the state expect this to take more than 1 day?
No, the state expects this to be finished in 1 day.
Okay. And you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses, so I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and respond. Those will due by today. So if you've got them, get it to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, anything else that we need to discuss in this case?
Yeah, I'm gonna ask to have my attorney removed, and I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from TV, this is from going through the law book and studying day in and day out. Everything I got the case numbers, case laws, I got.
Motion, what kind of motions are you talking about, Mr. Taylor?
But one is a motion to suppress. One is, I got one here, it's
motion to suppress, but this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
Here it begins the Sovereign Citizen Starter Pack. Filing motions you're not allowed to file, interrupting the judge, and pretending Google is your law degree. The judge is already laying it out clearly. Only. Your attorney can file motions unless you officially represent yourself. But this guy? He wants it both ways, legal authority without the responsibility. It's like demanding to fly the plane while still sitting in coach. Spoiler, this doesn't end well. Anyone else catching that I watched Law and Order once?
I know that. I'm saying is, what is it you think should be suppressed and why? What's the legal basis for it that you, being a non-lawyer, has come up with that an accomplished lawyer has not?
Got from my paperwork here. None of you organized here at the same time.
So you have an answer. What is it you would seek to suppress?
I don't know.
Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to have my attorney move from the case and have another one, please.
Wait a minute. I'm having trouble understanding you. I can hear you.
I'd like to remove my attorney and get another one.
Okay, well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So, he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another court-appointed attorney. I can't afford an attorney.
No, you have a court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, he's not going to do that. So, unless you can tell me why he is not, he shouldn't be your attorney, then you've given me no reason other than the fact that you don't like what he's saying and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything because a new attorney wouldn't be able to file frivolous motions either. And if I gave you any attorney who knows what they're doing, they're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time. Now, anything else you want to bring up?
Yes, I have grounds, man.
I asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
I'm be respectful. Wait till you're done talking.
I'm sorry, what?
Don't be respectful, man. Wait till you're done talking. You got only once for interrupting.
Okay. I asked you to answer my question, and you didn't when I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that.
You already know this trial is going to be a circus. He wants his attorney gone, insists he knows the law better. Then can't explain anything. The judge practically gives him a golden opportunity to defend his logic, and he just crumbles. At this point, you have to ask, is he confused, arrogant, or both? Or is this just performance?
I don't think there's any way in the world you could represent yourself. Pardon me?
I haven't been able to tell you nothing.
I can't understand your mumbling.
I haven't been able to tell you anything.
Well, you're not the attorney. You know, you're on trial. You don't get to participate in your defense because that's what an attorney is for. That's why you have one.
But am I allowed to have a fair and just defense?
Oh, absolutely, and then that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
I don't have all my discovery. I'm missing 12 things that I'm undiscovered. I'm begging for.
Well, he's got the discovery. Well, let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, I mean, my understanding, he's given you more than what most defendants get in these kind of cases, because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of what they say are the buys, right? And then you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kerr?
He's not just shutting the nonsense down, he's educating the public on what real courtroom procedure looks like. Brian's mistake. Confusing access to legal texts with understanding of legal strategy. This isn't a Reddit thread, it's a felony case. And no, reading a few pages of Ohio code doesn't mean you can outsmart a veteran prosecutor. In a courtroom, the judge is right. Reading a book on brain surgery doesn't make you a neurosurgeon, and this guy, he's performing lobotomies on his own.
I get impeached 1 week, I get impeached 2 weeks later, and I get impeached Monday.
All right. Well, good. It gives you something to do. So what? We still got 10 or 12 days to trial. I mean, but again, you're not going to be the one that's going to be questioning the witnesses and presenting evidence and making arguments. That's what your attorney does. Pardon me?
Well, I'm afraid of.
I would be afraid too if I were on trial, but that's not why we're here. This is a final pretrial, and we're ready to go to trial. The court, we're going to send out our jury notices today. State's ready to go, and you're going to be ready to go unless you get a new attorney. And again, you're not going to get maybe you can find somebody to be willing to take the case and go to trial on the 7th. But that's going to be on you. If you want another attorney, you can get one. But all this stuff you're telling me doesn't amount to a hill of beans, as my dad would say.
I represent myself.
Pardon me?
I represent myself.
Well, if you want to do that, how are you going to do that? What do you know about the law?
I don't know that much about the law.
And so you want to go to trial not knowing much about the law against a prosecutor that does know the law?
I think my percentages would be higher, yes.
Pardon me?
I think I would have, my percentages would be higher, yes.
Well, I can't understand what he's saying.
Yes.
He said his percentage would be higher. His percentage of winning would be higher if he.
Oh yeah, what do you think that would be?
I don't know.
Well, give me the odds. I'll take that bet. Because you're absolutely 100% wrong. Everything you're saying here is exposing the stupidity of your position. And for me to allow you.
Brian keeps claiming he's missing documents, videos, resumes, and secret evidence, yet his lawyer and the prosecutor both confirm he has everything that matters. The real issue here, he doesn't understand what he has. It's like giving a toddler a tax return and expecting them to find the deductions. His confusion is being mistaken for conspiracy. And that only weakens his argument further. But credit where it's due, at least he's consistent.
Motion to seven.
Well, we don't get separation of witnesses, I ask you.
Yes, yes.
Okay. So what is it?
I asked 5.
Huh?
Motion I asked him to 5.
Okay, well, that is filed at the time of the trial. When we start the trial, that's an oral motion. What kind of a motion did you want him to file?
You have to give me time to get it.
No, you're the one that claims to know more than he does. You should have been prepared to tell me. If you've got all these arguments, don't tell me you got to sit there and try to figure this out, because we're not going to sit here all afternoon. You tell me what it is you wanted him to file. You just told me you wanted him to file something. Tell me what it is you wanted him to file. Don't tell me you got to go look for it.
I'm pretty organized here.
Well, why can't you answer the question then?
Because I can't tell you without.
Okay, well, look at it. You should be able to find it.
Truly, Try asks Brian what makes him think he'd win against a trained prosecutor if he represents himself. Brian's answer, my percentage would be higher. That's not a legal theory. That's Vegas odds-based. On vibes, he can't define voir dire. He can't explain his own motions, but he believes he's got better chances without a lawyer. This isn't Confidence's courtroom self-sabotage on